And so I'm really worried about that, particularly, again, I think this, I said this really, it's kind of ironic that, you know, this, with the time, the passage of time has kind of calmed down, you know, that in terms of the media, very heavy initially. I have to say that to be here today, but the streaming has probably helped a little bit. Sort of kind of slowed things down intentionally, but I think, you know, people kind of move on a little bit, and then all of a sudden they get a phone call from a stranger talking about particular issues in Kohberger case, and so it kind of fires it up. And that's one of my worries. Also, just the fact that you can say 400 people, but 400 people in town spreads really thin. So it is dissemination. And I'm no expert about it. I don't know if I think you probably should. Mr. Edelman's been hearing this whole hearing, so maybe a discussion with him, maybe even a discussion with each other. I mean, everything's kind of out in the open.
Sure.
I'm very grateful. I'm very grateful for that, because I like to know to some degree what's happening in this case. And let's just deal with it really quickly. But I don't know, maybe we can next week.
Judge, I plan to be in town on the 11th. If the court wants a hearing, I can make myself available really any day next week. I already have plans for the 11th, but I can be available any other day the court wants.
So I'm going to be sitting with the Supreme Court in Nez County. So could you maybe have a hearing, short hearing of some kind, maybe on April 10th? Or,
Your Honor, is that a Wednesday?
yeah, that's what
I will if that's the only time the court has. Wednesdays, I have different things, but I can cancel them if that's the only time. If the court wants me to come back Monday,
I'll work
I can.
with you.
I could, 3 o'clock in the afternoon would be easiest for me on that day. On the 10th.
I have a treatment court meeting 2:30 to 3:30.
I can do 4 o'clock, or if the court wants to do it at 1, I can make that happen too.
Hey, Judge, I'm confused. What are we gonna have a hearing on?
Well, I want to see what thoughts you all have about dealing with the situation now, making sure that we can salvage anything or nothing. And Ms. Taylor's going to talk to Mr. Edelman, and maybe that'll give us some thoughts. Otherwise, I mean, I could just make the decision right now, but I'm no expert about surveys.
I understand. Thank you.
So I don't know how you feel about 4 o'clock on April 10. Could we just do that by Zoom, or do you want to be here?
Your Honor, Zoom would be fine with me. Mr. Kohberger would likely not be present. If he's present by Zoom, I will be here with him. So.
Okay, I mean, well, we can do it in person.
Let's go ahead and do it in person. I'll change my visiting day to Wednesday instead of Thursday.
Okay, is that okay, Mr. Thompson?
Yes, sir. We can be here 10th, 4 o'clock.
And, you know, Ms. Massif or Mr. Nye or Ms. Beatty can participate by Zoom.
Thank you. Yes, sir. Thank you.
Because I want to make the best decision I can, if that's possible. Okay, let's talk again about, you know, having a
hearing at least every month. It's just like cleaning up. And also, I guess you just did have a stipulation that you filed. But I have some, there it is. There's pending the state's motion to temporarily seal Exhibit 1 in the state's response to defendant's 12th supplemental request for discovery. Is that?
That would be,
Clean this up.
that would be covered by the stipulation that we filed today.
Yeah,
Okay,
the goal with that, Your Honor, is we often want to file those attachments to discovery under seal. Those contain things that shouldn't be made public. We both agree to it. And originally we were getting stipulations. And then I think we've done it so much, we just started doing orders. So the purpose of that is for us to just send along those and with an order for under seal, knowing that I'm always going to stipulate to attachments to discovery responses to be under seal, and the same with them. I mean, we know what we're each asking. So.
okay, and I worry about the clerks too. Okay, so if you could just have a stipulation that says, with regard to discovery responses, you can go ahead and see. Okay, I mean, as long as it's justified.
And that's the intent of what we submitted today, Your Honor,
Okay,
is that attachments to discovery requests and discovery responses, not the cover document itself, but the attachments that have the details would just automatically be sealed when we're stipulating to that. So that would be routine.
okay, great. So you backed off a little bit there, Taylor, Ms. Taylor, in that particular, you want everything, a hearing, or, everything needs to be stipulated.
That is a stipulation,
Well,
Judge.
it is, okay.
We also, Judge, I believe we have some other things on the motion to augment the record. We've been
Yes.
gathering more information on that, and it's my fault that I dropped the ball last month and didn't get a second batch of information compiled to Ms. Taylor. She got that today. We are contemplating that we will be able to present the court with a stipulation on that issue as well, with certain emails and communications attached to it, and then also have an ongoing stipulation about off the record communications, email or letter communications involving the court.
Excellent.
So we're making progress. We're working together on as much
Happy
as
to
we
hear
can.
that. There was also a defendant's motion requesting additional deadlines that was filed on March 6th. We didn't ask for here.
Your Honor, I haven't asked for a hearing. I know the state filed an objection to that, and we don't have a hearing on that yet. My thought would be that after we submit everything on our motion for venue change, when the court's ready to make a decision on that, I think that's when we'd probably call for a hearing on our motion, and probably the state would want to be heard at the same time on their objection.
Okay, so that can just hang out there for a while.
I think so.
Okay. Then we got state's motion to unseal. State's motion for order of prohibiting contact with the prospective jurors absent leave of.
Which relates to what we've been talking about today, Judge.
Yes, I know.
We had filed our original motion under seal. The initial response from the defense was under seal that said we object. And then the defense's memorandum with the attached affidavit was not filed under seal. So our position was that in fairness to the public record, that our motion should be unsealed and just keep the attachment sealed to protect the identity of the people who were interviewed by law enforcement or contacted law enforcement about being subject to the survey.
Any objections, Taylor?
In large part, no. There is a sentence in there where the state talks about evidence they plan to present, and that would seem like something they may want redacted before it became in the public record. Our response didn't have anything like that. I can show Mr. Thompson later, so in case he wants to prepare a redacted one for the board.
Do you know what she's talking about?
I don't, but we can talk about it, Judge, and Ms. Taylor can just show us or send us what the language is. I'm sure we can work it out.
Okay, and
So, and I guess this, we are already covered by the stipulation, defendant's motion to file exhibit M attached to defendant's 14 supplemental request for discovery.
That would be covered by today's stipulation.
Okay. Okay, I think I've had my speech, so.
Thank you, Your Honor.
So we don't need to hear from Mr. Nye or Mr. Edelman at this point.
I don't believe so. I think that it may be more prudent for Ms. Taylor and Mr. Edelman to talk between themselves first. And I believe the due process issue that Mr. Nye was prepared to discuss has been resolved.
Okay, I have no doubt that I did not violate due process rights
Yes, sir.
of Mr. Kohberger.
Yes, sir. Thank you.
Okay, anything else, Ms. Taylor?
Not today, Your Honor. Thank you.
Okay, great. We are adjourned. Thank you all. Thank you for your patience.
Thank you, Your Honor.